11th episode of the 39A podcast. This is Devina Malaviya from Project 39A. In today's episode, we are in conversation with Shreya Rastogi, Head of Forensics and Litigation at Project 39A, and Devina Sikdar, a forensic scientist with specialization in forensic biology who is part of the forensics research team. Thank you both for joining us today. The topic of today's conversation is understanding forensic DNA profiling in India. The DNA Technology Regulation Bill of 2019 was listed for consideration in the monsoon session of the Parliament. However, it has not been discussed in this session. This bill has received significant attention in the last few months, with serious concerns being raised from the aspect of privacy and civil liberties. Though this bill has been under scrutiny in recent months, it has had a tumultuous history. A draft of the bill was formulated by the Department of Biotechnology in 2005. Since then, the bill has been subject to various changes by the Ministry of Law and Justice, by the Department of Technology, the Directorate of Forensic Science Services, Ministry of Home Affairs, an expert committee, the Law Commission of India. The bill was introduced and passed in Lok Sabha in January 2019. Due to dissolution of the Lok Sabha, the bill soon lapsed. In October 2019, the bill was referred to the Parliamentary Standing Committee, and the committee submitted its report in February of 2021. Shreya Rastogi here has deposed as an expert witness before the Parliamentary Standing Committee. Before we begin the discussion on the bill, it is important for us to examine the process and science behind forensic DNA profiling, the myths surrounding it, and the application of forensic DNA profiling in the Indian legal system. Devina, if I can first come to you, can you explain to our audience the process of forensic DNA profiling? What are the various steps involved in it? And what information can this examination give to us?
Right. So I think before we get into the explanation of forensic DNA profiling, it's important for us to understand what DNA is. Now, DNA is a molecule that's found in our body and contains our genetic information. We inherit this from both our biological parents, and it is found in every cell of our body inside the nucleus. What is interesting to know is that 99.9% of the DNA is exactly the same across all humans, and only 0.1% is unique to every individual. Forensic DNA profiling is a process wherein we examine certain portions or certain locations of the DNA molecule and not the whole DNA molecule. Basically, what happened was that research showed that DNA had greater distinguishing power than, say, traditional evidence like fingerprints. So, highly variable sections of the DNA were picked and then examined to use it as a distinguishing factor between two individuals. As I've mentioned, 99%, 99.9% of DNA is same between individuals. Therefore, as a technique, forensic DNA profiling, because it examines certain sections, it's probabilistic in nature because there is a possibility that certain sections may be common. For example, Shreya and I can have certain sections that are being examined which are highly common, and therefore, as a examination process, as a technique, forensic DNA profiling is probabilistic in nature and cannot uniquely identify any individual.
That's very interesting, this point about forensic DNA profiling being probabilistic in nature. Because I think popular culture, in movies and crime thrillers would have us believe that DNA reports are expressed in terms of 100% match. And that is what DNA profiling is in the imagination of most people. That there is a report which says that there is 100% match and the case gets solved. So then I'm assuming that these results are actually scientifically inaccurate. There cannot be 100% match.
Absolutely. As I just said, forensic DNA results are probabilistic in nature. And actually, the results can only determine the rarity of a profile in a given population. Scientists usually have to calculate statistically the probability or the likelihood of a DNA profile based on population genetics information. So, all forensic DNA profiling results should definitely be reported with such statistical evaluation. And reporting simply a match is not only scientifically inaccurate, it is legally as well misleading, because uniquely identifying anything through forensic DNA profiling is not possible.
Right. Thank you so much for that explanation. I think understanding the science behind this process will also help us in then understanding its use by the criminal justice system. So, moving on, Shreya, can you elaborate on the various ways in which legal systems have relied on forensic DNA profiling? And specifically, how has the Indian legal system relied on it?
So the Indian legal system has used forensic DNA profiling since the early 1990s, and it has been used in a variety of civil and criminal cases. In terms of the civil applications of DNA profiling, it's primarily used in cases for paternity testing to determine the parentage of a particular individual. And in civil cases, forensic DNA profiling is used in a variety of bodily offenses. So, for instance, for investigating cases of sexual assault, rape, and murder. What's important to understand is that in criminal cases, the application of forensic DNA profiling can help us in answering a variety of questions. So, for instance, if there is a deceased person whose death is found to be in suspicious circumstances or appears to be homicidal in nature, and the investigating authorities are unable to identify such a deceased person, then they may first and foremost use DNA profiling to figure out and find out their identity. Also, in cases where there is a particular suspect that the police have in mind, then the evidence which may be collected from that particular accused, or the evidence that is collected from the victim. So, be it any kind of biological samples, like in cases of sexual assault, the swabs taken from genital organs or oral swabs that are taken from the victim, those may help in identifying the identity of the accused in case the accused DNA is found to be deposited in those samples. Similarly, if in case the accused DNA is found on the clothing of the victim or vice versa, even that may be incriminatory in the particular facts and circumstances of such cases. So what's important to know is that in and of itself, DNA does not prove the guilt of a person, and all that DNA profiling is able to tell you is the presence of a person's genetic material on another object, right? It does not directly answer the question of guilt. And therefore, in any case where DNA profiling is being submitted as evidence, there must be other corroborating evidence towards the determination of guilt. I should also add that DNA profiling and the science of DNA profiling, as it's currently being used, it does not help us answer the question of how long the DNA has been deposited on a particular object, and whether that person directly deposited their DNA on that, or if the DNA got deposited via transference. So that is to say, if I shake Devina's hand and Devina then touches another object, then my DNA could land up on that object through DNA transference. And research has shown that DNA is highly susceptible to transference, which therefore kind of reduces or has an impact on the probative value of DNA in criminal cases. The other applications of DNA profiling include identification of unknown deceased persons, like in situations of mass disasters, or identification of missing persons.
Thank you for that explanation, Shreya, for helping us understand the various cases in which, the range of cases in which forensic DNA profiling can be used. So, given the importance of DNA profiling in the legal system and its various applications, as Shreya has outlined, Devina, can you tell us about how forensic DNA profiling is being regulated in India?
Right. I think before I get into the practice of forensic DNA profiling in India, it is best for me to explain the current structure of government labs functioning within the country. Bulk of the forensic DNA profiling work is carried out by government forensic science laboratories within DNA divisions that function within these government laboratories. The labs submit results to the court. Criminal casework requires only government forensics laboratories to submit reports. For civil cases, private labs can be consulted as well, and they can submit the reports to court as well. Forensic DNA profiling, as I mentioned, is carried out within divisions in these laboratories, which are spread over three tiers. So we have central laboratories that come directly under the Ministry of Home Affairs, and each state has their own state labs under which regional labs can also be present. Now, state laboratories, they come under their respective states' home or police department, and bulk of the forensic DNA profiling casework is actually being carried out by these state and regional labs. In recent years, the government has put plans in motion to create dedicated labs specifically catering to just forensic DNA profiling casework. But as of now, there's just one such lab in India, which is the Center for DNA Fingerprinting and Diagnostics that functions under the Department of Biotech. And as of now, that is the only dedicated DNA laboratory functioning in our country.
So, then within the structure, as you've explained, how are these laboratories being regulated, and are these laboratories using the same standards across the board? And how well do they fare in comparison to the internationally recognized best standards?
Right. To assess how well DNA divisions, or for that matter, forensic laboratories, are being regulated, I think it is important for us to understand quality management and quality assurance. These are foundational principles that ensure that the laboratories follow the set standards, international standards across all types of lab procedures. And this includes procedures like for collection of evidence, handling of evidence, different types of examinations that can occur across divisions. And the different steps followed during these examination and analysis of evidence. Quality assurance, therefore, requires the labs to clearly identify and document these standards. So, internationally known best practices and scientific standards are then adapted as per the laboratory's conditions, and these are documents that should be maintained, and therefore ensuring that the laboratory themselves are applying this to their casework, and that scientific standards are being maintained across all types of casework, across different staff, help maintaining the overall reliability and validity of the casework itself. This is to ensure that a certain scientific technique is applied reliably across all cases and by all staff members. Quality assurance therefore requires laboratories to apply for accreditation, a process by which it is evaluated that these standards are being followed across all divisions of the laboratories and the complete procedures are being followed. Unfortunately, only a handful of labs are currently accredited. NABL is the organization in our country which provides accreditation, and currently only eight government forensic science laboratories are accredited by NABL. It isn't to say that unaccredited laboratories don't follow quality assurance measures, but from the surveys that have been conducted of the forensic science laboratories, the ground reality is very different. As part of our fieldwork for our forensic survey, we have observed the forensic laboratories, and we have noticed that poor infrastructure is a major issue in a lot of these laboratories. There are issues about vacancies and a lot of administrative challenges, which overall affect the quality of examination in individual casework. This has been mentioned intermittently by media reports as well. Several high courts across states have taken cognizance of the state of these laboratories. But unfortunately, such administrative challenges require greater policy intervention before any change, substantive change, can occur.
Devina, I think you've highlighted a very important concern of the poor regulation of laboratories, and that would certainly have an impact on individual cases. So, Shreya, the concerns which have been outlined by Devina, are these recognized by courts in individual cases which rely on DNA profiling?
So, just as there are issues that exist within forensic laboratories, we also have issues within the legal system which hinder a proper examination of the forensic reports that are submitted to court, including DNA profiling reports. And these issues particularly arise from the fact that till now we've been unable to develop clear legal standards which would test the scientific validity and reliability of the forensic evidence that is submitted to court. While the issues that Devina has just talked about the quality of forensic testing and the lack of quality assurance measures within laboratories, uh, uh, I fully agree that those are issues that should not only concern us as individuals at a policy level as we talk about regulating the forensic science system in India, but they should also be a matter of concern in the context of individual casework that the court is adjudicating upon. The legal inquiry, like I said, there are limitations to it so far. And currently, our legal inquiry on expert scientific evidence is largely guided actually by precedent, where courts are more concerned with looking at whether a higher court or an earlier court has already relied upon the use of specific a forensic discipline that they are or a forensic report that they're looking at, whether courts have previously looked at this and relied upon it, or it's also largely guided by the fact that there is common knowledge that specific disciplines are well established around the world. So, for instance, in many of the DNA cases, you will often find trial courts, high courts, or even Supreme Court for that matter, talk about the fact that DNA profiling has been established for so many years, that DNA profiling can provide us with 100% accurate and unique results, and that DNA profiling is foolproof. So these are some of the observations that have actually been made by courts, and science tells us that how erroneous these observations are. So something that allows such observations to come into the courtrooms and into our judgments, I believe, is the fact that we lack rigorous legal inquiry on issues of examining expert evidence. And this is something that applies across the board. This applies to the practice of all kinds of forensic disciplines, and not particularly to the way in which DNA profiling results are scrutinized by courts.
Right. So I think the issue then is no is one is of course how the courts understand forensic DNA profiling, but also that because the law on expert evidence is not properly fleshed out, that does lead to deficiencies in the court's examination of forensic evidence in general, and that's not just limited to forensic DNA profiling. So, we have discussed the challenges surrounding forensic science disciplines at large, whether it is laboratory regulation or the legal examination of forensic evidence. In this context, then, how do you view the DNA profiling bill of 2019?
Although this is the first instance in India where we have a statutory requirement of accreditation of laboratories, um, I highly doubt the implementation of such a regulatory mechanism. I think the bill fails to sufficiently consider the current status of the laboratories and the accreditation structure that is presently functioning within the country. For instance, the bill requires the laboratories to get accredited within 60 days, which I think is highly unlikely, especially considering the current infrastructure of the laboratories. The bill also envisions a separate accreditation scheme for DNA divisions. And as I've said earlier, DNA divisions largely function within government forensic science laboratories. We do not, as of yet, have dedicated DNA labs. And I think this scheme that is being proposed in the bill will clash with the current administrative structure that is present. Because you have certain laboratories that fall under the Ministry of Home Affairs or under the state home or the police departments. Aside from this, what the bill fails to consider is that accreditation schemes and quality assurance is something that should be applied to the laboratory as a whole, and it cannot be specifically targeted towards DNA divisions because there are going to be laboratory procedures that will supplement the examination that happens within DNA divisions, and therefore having a specific accreditation scheme for DNA laboratories may be highly problematic. And I think, in that sense, as much as I appreciate this move towards statutory accreditation, I believe it is very likely to fail in its implementation.
If I could just come in here, in addition to what Devina said, another important aspect about obligations for accreditation that the bill introduces, one thing that we should consider is that while the bill is the first attempt at making this a mandatory requirement, interestingly, the bill also does not provide any consequences for non accreditation, which is to say that if in case a DNA laboratory fails to get accredited within the stipulated period of time, what would be the fate of the evidence, the DNA evidence that such a lab has created and submitted to court? What would be its fate within courts? Can such evidence still be admitted by courts as evidence? Or can courts no longer rely on it? So the bill does not make any mention of that. Another thing that I'd like to highlight is that the bill has made attempts towards defining the obligations of DNA laboratories. And to the earlier point that Devina was making about the need for quality management in forensic work, I think these obligations can go a long way because they cover a variety of issues from ensuring that validation is conducted to having written analytical protocols. So I think that this change should be welcomed. However, there are some gaps in the way in which these obligations have been defined, and it's unfortunate that the bill has failed to address some of these issues because they would have assisted in the way in which DNA profiling is practiced in India. One of the major issues that exists in the practice of forensic DNA profiling is the lack of any kind of statistical analysis. So currently, the forensic laboratories are submitting DNA reports to the courts without an assessment of the rarity of the DNA profiles that they have examined from the evidence samples. And like Devina was explaining to us earlier, forensic DNA profiling is inherently probabilistic in nature. So that is to say that in forensic DNA profiling, we are not profiling the entire DNA strand, and we're only looking at a few specific locations in a person's DNA. There is a probability that another unrelated individual could have the same profile. And that is why around the world it is understood and it's an integral part of the practice of DNA profiling that statistical analysis is conducted and that that analysis is used by the fact finder, be it the judge or the jury, in granting any weight to the DNA profiles. So the lack of such kind of analysis by our forensic laboratories is a matter of grave concern, and it raises doubts over the scientific and legal legitimacy of the results that are submitted to courts.
So, the takeaway from the explanation that both Shreya and Devina have provided is that while the bill has taken certain steps which are important, it does not go all the way and it still has left many gaps. So finally, coming to the second aspect of what the bill seeks to do, which is creation of a national as well as regional DNA database. A lot has been said about it, especially its impact on privacy in the absence of a data protection law. Shreya, in your opinion, is there a need to create a DNA database and what is the purpose that it serves?
Right. So it's first important to clarify that the use of DNA profiling is different from databasing of the DNA profiling profiles that are created, right? Those are two different things. And we must acknowledge the fact that India has been conducting DNA profiling, forensic DNA profiling for more than 2 decades now, and during this time we have not had a DNA database. So therefore, as a system, we can continue to use DNA profiling for the purposes of resolving appropriate civil and criminal disputes without a DNA database. But at the same time, it's important that for us to understand what is the use of forensic DNA databases that exist in other jurisdictions. How have they assisted those governments and those the investigating agencies in those jurisdictions in resolving cases? Right? And the biggest narrative that comes forward and in support of having forensic DNA databases is the fact that it can assist in expediting criminal investigations in case of repeat offenders or in terms of identifying missing persons. So those have been the two main purposes for which there's been a significant push for forensic DNA databases. But as we get into discussing our own bill, we also must acknowledge what has been the experience of these databases in other jurisdictions. What have been some of the debates on issues of privacy and human rights concerns that have come up in those jurisdictions, and what can we learn from those as we look to debate the bill as it's pending before the parliament. And there we will find that from the experiences of other jurisdictions, we can see that there are limitations to using DNA databases as well. We must acknowledge that quality management of DNA databases has come up as a issue in other jurisdictions, and that just doing a search against the profiles which are there on the forensic DNA database can also sometimes box in the scope of investigation. So therefore, we must consider some of those pitfalls as we go towards building our own DNA database. Another aspect that we should think about is that best practices suggest that any forensic DNA database should be extremely limited and defined in its scope, and that mostly, I mean, it should be limited to storing the profiles of convicted persons as opposed to storing profiles of under trials of suspects in investigations. So that's another thing, another point on which the current bill departs from the best practice. And finally, I would say that the way in which the access to forensic DNA databases is monitored and regulated in other jurisdictions, we must also look to follow and incorporate some of those practices within the statute before we look to create a DNA database, because there are very serious privacy and human rights considerations for any person who might have their DNA profile stored on the database. So all of these issues must be appropriately discussed and debated before the bill becomes a law.
Thank you for that explanation, and particularly the distinction between DNA profiling and creation of DNA database, like you have mentioned. So now I'd just like to ask both of you that what are the issues which you see in the manner in which the bill envisages the creation of the DNA database?
So currently, the main issue that affects both the regulation aspect of the bill as well as the database creation is the way in which DNA profile has been defined under the bill. Now, the current definition is an extremely wide one since it covers the analysis, the result of analysis of a DNA sample for establishing human identification in respect of the matters which are listed in the schedule as annexed to the bill. Now, the words that we must consider here more closely is establishing human identification. That's an extremely wide way of defining DNA profile because it can include within its scope all kinds of applications of DNA profiling and not specifically forensic DNA profiling, which is limited to looking at specific markers that do not give you information about the physical attributes or the medical history of an individual. So the way in which it's currently defined, it could include those aspects as well. And because of that wide definition, everything else that gets defined in the bill, which that is to say, the definition of DNA testing, or then thereafter DNA laboratory, which is any lab or facility that is doing DNA testing, all of those get affected because of this broad definition of a DNA profile, right? The snowballing effect here is that when we think about the regulatory aspect, this would then mean that all DNA laboratories are covered within the purview of the bill because Section 13, I believe, mandates that every DNA laboratory must be accredited by the DNA regulatory board that is envisaged under the bill. And these such DNA laboratories must also then submit the DNA profiles that they generate to the DNA database. Now, the submission of the DNA profiles is not limited in the current draft. It's not limited only to those DNA profiles which will be relevant to the particular indices that are envisaged under the bill. And that creates a huge ambiguity because one wonders whether all kinds of DNA profiles that are generated will have to be submitted. So, for instance, a government lab doing DNA profiling in a paternity case, would the laboratory have to submit those profiles as well or not? And who would be taking those decisions? Would it be at the laboratory level or would it be sent to the DNA database and then it would be database in the particular index if in case it's relevant? If it's not indexed, then would the database still retain those DNA profiles? All of these are questions which are up in the air and therefore they give rise to concerns of ghost indexes being prepared where the DNA database might store and might collect more profiles than it's apparently supposed to, right? So these kind of concerns all generate from definition of the DNA profile and also the width of the schedule that is mentioned in the bill, and that is why these are two issues that have to be looked at more closely.
Picking from what Shreya just mentioned right now, one of the other things that we should be concerned about is the fact that the DNA bill currently envisions regional DNA database as well as a national DNA database. Now, as Shreya has mentioned, that the scope of the indices is vast because the DNA profile definition isn't really specific, as well as how the indices are defined in the bill itself gives rise to the possibility of ghost indices. This is highly sensitive information that we are talking about, and the fact that there are going to be multiple ways that this information is going to be stored is definitely a cause for concern. And this problem gets heightened because, as of now, the bill doesn't envision a quality management system for the DNA databases itself. So, as we've just discussed, the DNA laboratories have mandatory accreditation requirements, but the DNA database itself doesn't really have any such requirement. And we don't know whether a quality management system is being envisioned or not for DNA databases. Now, for example, if the examination in a DNA division leads to poor results, as I mentioned, that forensic DNA profiling just looks at certain sections of the DNA. And we also know that the evidence that comes in through casework isn't the most pristine. So it's very likely that the profiles that are generated aren't of good quality and maybe partial profiles. So, having such profiles being generated by laboratories and then eventually being uploaded onto regional database or on a national database without any oversight can definitely be a problem, especially when we know that there's a chance that these are going to be used for future searches. And this becomes all the more problematic given what Shreya has discussed in the regarding the legal examination of such evidence, and the fact that there is no statistical evaluation that's being happening currently in our laboratories. So poor quality profiles or partial profiles, if they're used and uploaded, databased, and then searches run on them, and then a simple match is then reported, it could lead to dire consequences in caseworks. So, therefore, it becomes really important for us to understand quality management system of DNA databases and have that in place before any such databasing of information happens.
Thank you so much, both of you, Devira and Shreya, for having this conversation with us. I think it has been extremely useful to understand and engage with you on all the points that you have covered, right from the science behind DNA profiling to the structure of forensic science laboratories in India, how they are regulated, how forensic evidence is examined by court, what are the limitations of such examination, how that impacts individual cases, and finally, the insights that you have provided to us on the DNA profiling bill. I think the background and the context which you have provided to us is especially useful when we move on to examine the bill and understand the various concerns it poses. This conversation has been extremely insightful and very informative. And I really hope that it guides future discussions on not just DNA profiling and the bill, but also forensic science regulation in India. So, thank you so much for this.
Thank you.
Thank you for having us.